Great to be back in my alma mater. Thank you very much for asking me along. When I was asked to undertake this paper, it was suggested that I undertake something like a what-if analysis, that I should examine the question of whether Dominion status might have been a suitable alternative for Ireland in 1916, an alternative that might have provided an answer to the Irish question of the early 20th century, an alternative that might have made the 1916 Rising far, far less likely to have occurred. I mean, you could see this as an exploration of an alternative history. Could giving Ireland a generous legal autonomy within the empire have offered a viable alternative in 1916? Well, at the dawn of the 20th century, Dominion status might have looked like such an alternative. Dominion status being, incidentally, the substantial and growing autonomy of the colonies of white settlement of the empire. So we're talking about Canada, Australia, New Zealand, South Africa, and Newfoundland, which wasn't part of Canada at this point. How could Dominion status have offered an answer to the Irish question? Well, it offered Ireland a generous measure of autonomy while maintaining the territorial integrity of the empire. It allowed for an expression of a separate Irish identity without creating a precedent in terms of secession that might have threatened the existence of this vast global entity. It offered self-government for the Irish population, while, as desired by the majority of the population, while maintaining links to the crown cherished by a significant minority. That's the stall. Now, as many of you know, alternative histories are generally frowned on by reputable historians, and with good reason. But actually, this alternative history is pretty easy to assess. Could giving Ireland autonomy as a dominion have offered a viable alternative in 1916? Absolutely not. There is no what-if here. No alternative history. Pretty short paper. No. There are good historical and legal reasons why this was so. Why a solution that was neither realistic nor appropriate in 1916 should, just 5 years later, have become both realistic and appropriate. So, the reasons are instructive. They're bound up with political and legal developments in Ireland and in the British Empire more widely. So let's start by looking at this very quickly at a general rundown of the legal structure of the British Empire in this period. Okay, you have the obvious link of the common law, not universal within the empire. For example, Southern Africa dominated by Romano-Dutch law, but for much of the empire a link, in fact, beyond the empire in the form of the United States of America. The monarchy, the most important of the common institutions uniting the empire. It's no exaggeration to say the constitutional glue that held the empire together. The empire legally was held together by virtue of common allegiance to the same monarch, which is why members of parliaments and assemblies of the empire had to swear oaths of allegiance to that monarch, which, of course, would later become a very thorny issue in the context of Irish history. You also have, as a supreme appellate court for most of the British Empire, this court, the Judicial Committee of the Privy Council, often credited with maintaining the unity of the common law as well as the unity of the British Empire itself. And then you have what was known as the Imperial Parliament. Yes, the Parliament at Westminster was often called this in the early 20th century. Obviously utterly inaccurate in terms of representation. The House of Commons only contained representatives from British constituencies. But in terms of powers, there was some accuracy to this term, because Westminster claimed the right to legislate for all of Britain's possessions in all parts of the world. Now, of course, usually it was more convenient to let local assemblies or local authorities deal with the day-to-day matters, but the Imperial Parliament did reserve the right to intervene directly if the circumstances warranted it. And it passed what was known as imperial legislation on all sorts of topics. Here are some examples. The monarchy, of course, citizenship, copyright law, maritime law, extradition, the armed forces, boundaries, all sorts of topics, including, by the way, all of the constitutions of the British Dominions. They were all enacted as imperial statutes, including, from a British perspective at least, our own constitution of 1922. Moreover, these imperial statutes enjoyed a position of supremacy over colonial and indeed dominion laws. You see this in Blackstone when he says that a local law that conflicts with an imperial statute shall be utterly void and of none effect. Now, that was held to be a fundamental principle of common law. It was also enshrined in statute in 1865 in the Colonial Laws Validity Act. And by the way, this supremacy was enforced, as the Canadians found out in 1926 when a section of their criminal code was struck down because it was incompatible with imperial statute. There was also a function known popularly as the Crown veto. Of course, all legislation, dominion, imperial, otherwise, had to get the king's assent. And the king, of course, was advised in practice by the British government. There were two types of veto: reservation, which was a delay for a bill, and the bill would either get assent or not get assent. And then there was disallowance, which was the vetoing of a statute that had already been signed into law and might have been effective for some time. Now, these vetoes were a device that the British used fairly often before the American Revolution. But of course, losing those 13 colonies had something of a sobering effect on the British in this sense, who went to the other side of the spectrum, became very reluctant in practice to use it, even in situations where perhaps they should have. For example, in 1887, the British refused to veto a bill from the Cape Colony, removing the franchise from non-white people. In 1898, they do the same. They refused to veto a bill from Canada, stripping most of the native Indians of their vote, which, by the way, they only got back in the 1960s. But we're straying a long way from Ireland here. What relevance did all of this imperial law have to her? Well, of course, in the early 20th century, all the focus was on home rule. But it is possible to argue that in some respects, home rule was a child of dominion status. Certainly all four of the bills and acts aimed at granting Irish home rule, the bills of 1886, 93, and the acts of 1914 and 20, were influenced by dominion models. I mean, this isn't so surprising when you consider that, the main experience the British had in giving autonomy was in the context of creating dominions. So the arbiter of all the home rule settlements, indeed often the Supreme Appellate Court, was to be the Judicial Committee of the Privy Council, just like in the dominions. All the home rule bills had some kind of equivalent to the Colonial Laws Validity Act. In addition, the thing about home rule is it didn't have any precedents to draw on. So commentators on home rule often used dominion ones to outline and support their proposals. Erskine Childers draws extensively on dominion status in his work on home rule that he published in 1911. He says that dominion status in Canada, for example, ought to be studied by every voter, however lowly, who has a voice in deciding the fate of Irish home rule. There was even the close relationship between the two concepts even resulted in the horrible hybrid dominion home rule. But of course there were differences. Home rule and dominion status, not the same thing. Home rule is autonomy within the United Kingdom. Dominion status is autonomy within the British Empire. In other words, dominion status involves some kind of international presence with the possibility of a pathway towards greater sovereignty. For that reason, it simply was not a realistic prospect for Ireland in 1916. It was a step far, far beyond anything any British government would have been prepared to give. And consequently, there was no significant political movement in Ireland in 1916 endorsing this solution. Indeed, it was little more than the idea of an Irish dominion was little more than a curious intellectual fantasy. But even leaving such matters aside, not all Irish nationalists even would have been prepared to endorse dominion status in 1916. Because at that time, it wasn't completely certain that it offered a stepping stone to greater sovereignty. Now, why do I say that? I say that because there was an influential movement that favored evolution in precisely the opposite direction. A movement towards what was known as Imperial Federation, bringing the United Kingdom and the Dominions, New Zealand, South Africa, Newfoundland, Australia, Canada, together in one global federal state. Yes, this was a serious movement. Not just advocated by one organization, but many. The most notable being the Imperial Federation League, which pioneered the idea until Prime Minister Gladstone decisively rejected their ideas. Their most influential successors was the Round Table movement, which contained a disproportionate number of lawyers, by the way. Their unofficial motto was always this: federate or disintegrate. Now, by the way, it wasn't all completely quixotic. They did actually achieve some solid, proposals. For example, they were the main drivers behind the system of imperial preference in trade. It was they who popularized the term Commonwealth as opposed to empire. It was they who really were the driving force behind the creation of the Imperial Conference, regular meetings between the United Kingdom and the Dominions every 3 or 4 years or so. So how did their ideas manifest themselves? Well, for one thing, they wanted to create a genuinely imperial parliament. And serious proposals, at least from the point of view of the proposers, were actually put forward in this regard. Let me give you an example. In 1911, at an imperial conference, the New Zealand Prime Minister, Sir Joseph Ward, suggested creating a brand new imperial parliament based on elected from all parts of the empire, the self-governing empire that is, 300 representatives, one for every 200,000 of the population, elected accordingly. Now, you see how the UK would have utterly dominated this parliament. And it might surprise you, therefore, that it was actually the UK who was the main opponent of it. Asquith was utterly uncompromising. He said it's contrary to the traditions and history of the United Kingdom and the Empire. His conclusion was damning. He said, we each of us are, and we each of us intend to remain master in our own household. Now, these proposals for coming together, having a genuine imperial parliament, were often accompanied by proposals for an imperial executive. Certainly Ward proposed one in 1911. Actually, that was one federalist proposal that looked like, for a brief period, it was actually going to happen. As a result of the pressures of World War I, many imperial federalists saw an opportunity. In fact, one of the notable things about the year 1916 is that you see a flurry of publications on this subject. At least 3 substantial books were published in innumerable articles. More importantly, in 1917, the British invite the Dominion Prime Ministers and representatives from India to London, where they would all sit together in an imperial war cabinet, something that was repeated in 1918, a federal government. Lloyd George trumpets it, a memorable landmark in the constitutional history of the British Empire, hopes it will become a regular event. It doesn't. And it doesn't because of the obvious impracticality of it, which General Jan Smuts, the Prime Minister of South Africa, pointed out. To attempt to run by a central parliament and a central executive, even the common concerns of a group of nations spread over the whole world, speaking different languages, belonging to different races with entirely different economic circumstances, is, to my mind, absolutely to court disaster. But it was in 1917 that Imperial Federation receives its death blow. In that year, the Imperial War Conference passed a resolution desiring constitutional change within the empire. But that constitutional change, it said, should be based upon a full recognition of the dominions as autonomous nations of an imperial commonwealth. Now, one young Australian writer saw this and wrote a book saying, it's clear this resolution was so framed as to shut out completely the solution of Imperial Federation. And this is, by the way, an important book in Irish history, Duncan Hall's Commonwealth of Nations. Why? Because this was the main textbook used by the Irish delegates in the treaty negotiations on Commonwealth and imperial affairs. Every member of the delegation had their own copy. Well, going back to the war ends, of course. The Dominions signed the peace treaties, become separate members of the League of Nations. Now, and of course, Home Rule is effectively killed by the 1916 Rising. It's the main competitor to Dominion status. And it's from 1917 onwards. Now, you get political calls for Dominion status. Now it becomes seen as a potential solution to the Irish question. You get the emergence of the Irish Dominion League, for example, in 1919, with its newspaper, The Irish Statesman, trying to move private members' bills, putting in place a Dominion solution. They don't succeed, of course, because the British government is still committed to the Government of Ireland Act of 1920. In 1921, Jan Smuts meets with De Valera, urging him to accept a Dominion settlement, just as the Boers in South Africa had done. And of course, Dominion status lies at the heart of the 1921 treaty. Opposed, of course, by many people for many different reasons. Wasn't the Republic that many people had hoped for? For some, a betrayal of the 1916 Rising. Still a few residual fears of Imperial Federation, by the way, at this time, which some Irish nationalists raise. But there was also the argument that Dominion status in Ireland wouldn't mean the same thing that it did in Canada and elsewhere. As I mentioned earlier, in the context of the Crown veto, quite a gap between law and practice had opened up, to such an extent that many people argued that the main factor that underpinned Dominion status wasn't law, it was distance. You can see De Valera making that point here. Certainly memories of 1916 were still close in 1921 and 1922. And by the way, they were not limited to opponents of the treaty. For example, it's worth noting that the opening provisions of the draft 1922 Constitution, sent to London to give the British a sneak preview, were taken directly from the works of Patrick Pearse, designed to create a direct link between 1916 and the new legal order. The British were horrified by them, by the way, not just because of their authorship, but because they saw them as rather communistic in their terms. They didn't make it into the final form of the Constitution. And memories of 1916 continue, even in the context of when the Irish government was negotiating key reforms of imperial law at successive imperial conferences. It was noted by many commentators that W.T. Cosgrave, the Irish leader, tended to appear for the very first day of the conference, smile for the conference photograph, and then go back to Dublin. Now, in private, Cosgrave explained that he was always self-conscious of his status as a veteran of the 1916 Rising, a fact, by the way, that people tended to forget in the 20s and tend to forget now. Cosgrave always feared that this might be resented by some of the other delegates and so damage the Irish negotiating position. So he made himself scarce. All this, of course, was in the future at the dawn of the 20th century. So I return to the original question. Could giving Ireland a position of generous autonomy within the British Empire have offered a viable alternative in 1916? No. It wasn't feasible as long as Home Rule was a preferred solution. But then, as I say, Home Rule was something of a child of Dominion status. But it was a child that had to die before Dominion status could become viable for Ireland. And in any case, in 1916, Dominion status hadn't quite evolved into something that could form the basis of a possible compromise. It's the final death of Imperial Federation, the unambiguous triumph of Dominion autonomy, the emergence of a new concept of Commonwealth, which changes the situation. Of course, the Dominion solution itself would be transient. It would be gradually dismantled by De Valera in the 30s. But it was an important transition, and one that's often underestimated, I think. To put it simply, the gradual and peaceful transition offered by Dominion status made possible the eventual emergence of an Irish republic, a republic that was simply not a realistic proposal at the time of the 1916 Rising. Thank you very much.